today is the day for the jury charge conference. No jury is present today. What does jury charge even mean, Emily? Well, charging the jury is what they call it when they send the jury back to deliberate and they read out all of those jury instructions. It will take over an hour to read all the jury instructions to the jury. And there's a set of instructions they get before closing argument and then after closing argument. And the attorneys will argue in the middle, the prosecution going first, then the defense, then the prosecution with their rebuttal argument. That doesn't mean that the prosecution gets double the amount of time. They have to split their time over those two arguments. The rebuttal arguments, you want to keep it simple, address the points the defense made. Those initial closing arguments from the prosecution, you want to see them lay out their theory of the case, go through the jury instructions. How do the facts of this case meet the elements of the crime? And for the defense, it's the opposite of that. You get their theory of the case and then the jury instructions on how these elements are not met. But what instructions they use is decided today. We also heard at the end of court yesterday that they're going to be arguing for dismissal again. That's not going to get granted, but we're going to see that argument again, saying that no reasonable jury could find these causes of action. The defense argued it before. They're going to argue it again. It's going to be roughly the same argument. Probably get a preview of what they think about the case, but the court's going to deny that. That is what's going to happen. And that is not a surprise to me or anyone. It is incredibly rare that those get granted during trial. We're going to do that today. We're going to see the charge conference. How long will the charge conference last? It just depends. But I am interested to see if there is a stronger argument regarding a charge to the jury about the holes in John O'Keefe's hoodie. We know that that keeps getting put off and off and off and off, but we will see. I'm curious to see where that goes. Are we going to see a argument a little bit more about the DNA now that there's no rebuttal case? Because the Commonwealth was like, well, we're going to have a rebuttal. We're going to have a rebuttal. Well, now there's no rebuttal. So what are we going to see with that? And are we going to see that missing witness, which is really a necessary witness charge? It doesn't mean someone's actually missing. So a missing witness charge, we will see that. I really thought after how hard the Commonwealth fought for those rebuttal witnesses that we were going to see them. And yesterday, at the end of the day, it was just like, wah, wah, and we're done. I'm still surprised that Brennan was just like, yeah, we're done. He fought and fought and fought and fought and fought for that rebuttal. I think even the court was shocked, just absolutely stunned.
I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction and proposed on page 4, reaching a verdict. Just, I will make it crystal clear, though. I think it was, and I was upheld on it. So I will make it crystal.
The individual indictment instruction is talking about finding a verdict on each individual indictment. I think it was clear. I think we can make it more clear, though.
If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of. That's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally could state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
What's the Commonwealth's position?
So, Your Honor, the Commonwealth's position is ultimately I defer to the court as far as whether or not it's an appropriate instruction to give in the final charge. What the Commonwealth will submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't.
Lally said the instruction the court gave to the jury at the time is sufficient, so they don't need another one.
So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolfe, confronted Dr. Wolfe with it as part of an accident reconstructionist cross-examination. and challenging Dr. Wolfe on several aspects. And this one was particularly apt, that the subject matter, not the manner of the examination, was, Dr. Wolfe, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? Dr. Wolfe started to answer, well, I know that there was cutting to, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened.
100% did that. 100% did that. And so Alessi's laying it out even more for the court. Look, the witness was starting to answer that way and then was cut off.
So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolfe, Mr. Brennan asked Dr. Wolfe about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022
That's not gonna happen.
from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolfe correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence.
The court might give the bulk of that. The falsely insinuating part is not going to happen. But the rest of it is not highlighting the issue while still discussing the issue. And the jury can decide if it was a false insinuation. But Mr. Brennan asked about holes in the back of the sweatshirt, and it is known by all parties, I think would be appropriate. It's known by all parties that these holes were caused by the crime lab. That says it without saying it. The court's not going to say that one lawyer falsely insinuated something.
There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolfe had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue.
That's facts.
So, to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury. I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. Therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful
understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in.
What?
That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally.
And the court is saying, if it wasn't shown to you at the time, you should have objected and said, excuse me, Your Honor, the Commonwealth has not shown us the exhibit. A charge conference is just that. It's discussion of what the jury will be charged with, often referred to as a jury instruction conference, depending on what jurisdiction you're in. But the jury gets their jury charge. That is the word that is used in particularly more formal courts. They are charged with the duty of rendering a verdict, and the instructions are how they do that. So going through what the instructions will be, how they will be edited, it's incredibly important for the lawyers and to know how it's going to go. And we heard that controversial instruction discussed by the court, didn't we? When the court was talking about the multiple indictments, and the court said that I think that instruction's pretty clear, and the Supreme Judicial Court agreed with me. So I don't know if we will see more about that particular instruction discussed, but we will hear it tomorrow. Things that were curious to me. The Commonwealth is not asking for any lesser included charges. That only goes to count 2. We will talk about the counts again, especially as we hear the jury instructions. Count 2 is the vehicular manslaughter count with the DUI, and it has lesser includeds. The defense is asking for those lesser includeds. What's interesting is that the court can give them even if the Commonwealth's not asking for them. That's not true in all jurisdictions. In some jurisdictions, if the prosecution says this is the charge, no lesser includeds, then they don't get given. Some of you are asking, what is a lesser included? With some crimes, you have the charged crime, and there are other crimes that are a part of it. When you have a charged vehicular with DUI, a lesser included can be just a plain DUI or just a plain involuntary manslaughter. They are charges that are all accounted for in the primary charge, but they are less serious charges. So those are the lesser included charges that are all necessarily included in that main charge. So if they don't find the intent for like an attempted murder, then you could have the assault as a lesser included of attempted murder because you've caused some harm, but you might not have intended that that harm kill someone. So with regard to just count 2, there are lesser includeds. The defense asked for them. Those will be included. I got a lot of questions. Why would the defense ask for lesser includeds? Well, it gives the jury room to compromise. And when you've seen jurors talk from the first trial, they had more leaning towards guilt on count 2 in the first trial, and the defense might want to give the jury somewhere to go, especially with the amount of statements that came in for Karen Read. A jury might not sit well with nothing. You give the jury room to compromise so that if jurors are like, okay, I'm definitely out on count 1 and 3, I'm not sure about count 2, but can we really say that it's more than a DUI or more than a lower level involuntary? It gives the jury room to compromise. But sometimes that's why prosecutors don't want lesser includeds, because it gives room to compromise. Sometimes the prosecutors are like, it's this charge or it's nothing. Decide. We're not giving you more options. But the defense is asking for those lesser includeds. And so the judge is going to give them. The defense also proposed a different verdict form than we saw used last trial. The defense argued over that verdict form last trial, saying that it was confusing, and then they have asked for a different verdict form. The court might not give it because the verdict form that they used is the standard verdict form. What's the remedy for that? Well, the attorneys have to then spend time talking about the verdict form during closing arguments. And the court gave them an extra 15 minutes for closing arguments. I wonder if tomorrow we will see the court giving a little bit more on that, but Lord, 15 extra minutes. Okay, but that is what the court said. And then the thing I was interested in hearing was the argument over the missing witness or necessary witness instruction, and the defense withdrew it. So they're not asking for it anymore. So we're not going to see a necessary witness instruction. The defense is no longer asking for it. And the court is deciding if there will be a more stringent or pointed special instruction on the issue regarding John O'Keefe's hoodie. Mr. Alessi asked again for the court to give a more thorough instruction about the questions that were asked from Dr. Wolfe. The Commonwealth said, look, an instruction was given at the time. That's sufficient. We're asking that no further instruction be given during closing argument. The court's going to decide on that, and we will see tomorrow. The court has indicated that she wanted the court staff to call the jurors and see if they could come in early. She wants butts in seats by 8:45 tomorrow morning to start closing arguments promptly at 9 a.m. The court has indicated that they will do closing arguments, which means the prosecution will go, then the defense, then the prosecution with their rebuttal at the end. Then there will be an early lunch. Then the court will do the final charging, which will take about an hour to read. She wants the jury to deliberate. The court also said, and this surprised me, she is asking the jury if they are willing to stay till 5 or 5:30 so they have time to deliberate tomorrow. The court wants to give the jury time to deliberate. And if they start at 9 and each side gets an hour and 15 minutes, that's 2.5 hours. So that will take them till noon. If they take a 30-minute lunch and then the judge reads instructions, they might have the case to start deliberating around 2 in the afternoon. And so from 2 to 5 would give them more time to deliberate before they go into the weekend. The court said she did not want to just have argument, charge the jury, and then send them home for the weekend. So we will see the jury getting some time to deliberate tomorrow. Will it be enough time? I don't know, but we will see. So the evidence is done. The parties have rested. The jury instructions are being edited, and closing arguments will be Friday morning, starting, the court says, promptly at 9 a.m. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.